There we go. I think we got it going now. All right. Again, I apologize for that hold up there, but I think we're up and running. All right, I'm Nathan Byerly. I'll start over again. I'm Nathan Byerly. I'm the Deputy Director at the Office of Open Records, obviously not in charge of IT. And I would like to talk to you today about data storage and the right to know law and how all of this intertwines into both the application of the law to real life and how many different times we see that in final determinations and appeals that we have before our office. Before I get started, I will behave like a normal and good attorney and give you all kinds of disclaimers. First off, I'm not an IT wizard. I'm not even an IT Padawan if you're a Star Wars fan. So I am not going to use technical terms today. So if that is something that is going to be an issue for you because you're an IT person and my use of common language or even use of perhaps technically the wrong term is going to bother you, this may not be the presentation for you. Another disclaimer is this is still a developing area of the law. We, especially with the COVID and the pandemic situation, we have seen, and even in some respects to the election results cases and some of the databases that we've seen requests related to, there's been an increase in this area. We'll discuss a little bit later, the ramifications of that and how that's applicable and how it's changed things, but it's still a developing area of the law. So there's not a lot of specific guidance out there for us to refer to. And the last one is, and having conversations about this presentation leading up to it with a number of different people and discussing the subject matter, this session is probably going to end up causing a lot more questions than answers. And that's good in some respects because as you file requests with agencies for information, you can work on making your requests clear and help us develop the law in this area. As you're an agency, you can explain things to us and maybe in a little better and more detailed way, and we can work together to be able to answer some of these questions that invariably come up in any given day before the Office of Open Records in handling these appeals. So I was thinking about the presentation today, and we all know, and it's quite clear that government collects a large amount of information and data. It's just the nature of government, and it seems more and more government is collecting more and more information, and there are more reasons to collect information. But even today, the alarm clock goes off, and instantly, it's either electricity or it's a cell phone if you use a cell phone to wake up, and there's government regulation of that. So the government's collecting records and information related to utility companies and electricity. Get up, walk in to brush my teeth, there's the water. Now I'm dealing with potentially a water authority impacting my life. And if I pay the bill timely like I should, that agency potentially could have records related to my financial information. They could have information related to invoices or billings that are sent to me. If I fall behind and don't pay for a number of months, I'm assuming they're going to initiate some type of court action. Now you're talking court records. So I'm done brushing my teeth. I walk down the stairs. Hopefully I don't stub my toe, but if I stub my toe and need to go to an urgent care or to an ER, now we're talking health records. And that impacts any number of data points and information that a government entity may collect in relation to monitoring the health care that is given in the Commonwealth. I walk out into the garage, get into my car. Now we're talking Department of Transportation records impacting my life. My daughter gets into the car next to me. I go to take her to drop her off at school, and we're talking education records. During the course of the day, I'm going to drop off, some tax information because it's tax season. Taxes is another area of information. So as you see, and as I'm sure all of you know, the amount of information that's collected, the amount of information that is stored is immense from any given time, in any given day, in any given subject matter. Likewise, storage varies. We go back in history, and there's paper records from hundreds of years ago. Microfiche, tapes, DVD, CDs, all the different types of backup mechanisms that have been produced over the last 30, 40, 50 years that have been quick and rapidly developing. Database, data sets, there's external devices, all kinds of drives, computers, tablets, phones, Now there's the cloud. There's the overwriting of data that's involved with the cloud. There's all kinds of backup servers. Again, CDs, tapes, paper, floppy disks. Remember the old 3.5, 5.5. So any number of types of ways to store this, which then made me stop and think, talking historically. Let me take a step back and look at the perspective of the law in 2009 when it was passed and when the Office of Open Records was created. Well, actually, it was passed in 2008, but the Office of Open Records came into existence in 2009. We were at an iPhone 3 at that point. BlackBerry was a leading company in this in the IT world, in the cell phone industry. Facebook was only 3 years old because it was open to the public in 2006. Twitter also started in 2006. And there was no Instagram, to which, depending on your name or your age, you may hear, no Instagram, what do I do? So just to put that in context, and I know that not all of that deals with data storage, but it is, again, production of information and looking at the creation and how much it's changed with the use of Facebook and Twitter and even Instagram. You look at the issue of BlackBerry now being non-existent, a leading company going away for all intents and purposes. What happened to all that data? And I know it's not government storage, but government used BlackBerry devices, and what happened to that information? It's just an interesting concept to think of going forward. Storage practices may become obsolete because companies either go out of business or change their approach. And as far as the iPhone 3 goes, how much more storage do you have on your, I think we're up to iPhone 13 now. How much more storage do you have on that device than you did on the iPhone 3? And even the computers, laptops, even drive devices and flash drives that we have now, how much more data can you get on those devices than you used to in 2009? So even from 2009, the passage of the law, till now, we have a huge difference in the type of devices. And what I found very interesting, too, is when I walked around and talked with different people about this presentation, and I talked about this perspective in 2009, and I joke about the gasp with Instagram, but in mentioning that to different young people, that was the reaction. Wow. And the harassment you get for a teen, even for the iPhone 3, my daughter thinks I'm archaic because I have an iPhone 8. But there was other people I talked to that were just surprised at the statistics. And there were other people, on the other extreme were like, all of this means nothing to me. And I thought odds are very high that across the Commonwealth, you have agency open records officers with different levels of expertise, different levels of knowledge, and different levels of training on the issue of data and data storage and information. So on any given day, you may walk into an agency, hand a right to know request or email in a right to know request. Someone in the agency may give it to the arrow too and say, hey, we need you to go into the database and track down the responsive records to this right to know request. Depending on that person's expertise and knowledge, you're going to potentially get different responsive records with the person who has limited knowledge runs the search and goes and looks, and the person with advanced knowledge goes and runs the search. And obviously there's a range in between those two that could potentially bring back different results. So it's just an interesting dynamic that impacts this and begins the questions really from the get-go of what all goes into data recovery and the issues that are involved there. So I always like to start out and give a purpose and the reason and the goals for having trainings that we do and discussions like this. And I almost look to today as being more of a discussion than, from my end, than a training. We really want to, as the Office of Open Records, draw attention to how agencies store information and just kind of put up a warning flag that you may need to change, update, or upgrade how you do that. You may need to make it easier to get those records out. And this today is going to hopefully show that to you, that is something that your agency might need to address. Draw attention to the legal responsibilities under the right to know law. Some of these cases that we're going to be talking about, and that's one of the unfortunate things in this area of the law, is there's not a lot of new law. And by new, I mean in the last 4 or 5 years. Some of the cases date back longer than that. So we're looking for a little bit more guidance, and sometimes it's easy to lose track of those cases over time. And I want to highlight the need to agencies especially to explain the capabilities to an appeals officer during your appeal. So when we have like a database or a data recovery or withdrawing it from some type of software that you may have that allows you to organize your records, really take the time to explain the capabilities and explain the type of search that you did to try to find those records so that the appeals officer knows the ins and outs and makes sure and certain that a proper and legally appropriate search has been conducted. And it's not a half bad idea to share that with the requesters at the request stage too. Sometimes some of these appeals come in and there is legitimately no way for the agency to get the information together and give it to the requester. It's just not the way the system's made. And explaining that to the requester at the request stage will sometimes hopefully avoid an appeal. Obviously, I cannot guarantee that every time. And then just to emphasize it again, I put another disclaimer in here. This is still a developing area of the law. And again, we're probably going to be looking at a lot of questions that we walk through here, and they're questions that you as an agency can take and even rhetorically or helpfully use to ask in your agency to perhaps make some changes. And as a requester, ask these questions that are going to arise today to formulate a right to know requests so that they are more effective and in all honesty, more efficient for the agency to be able to process. I also like to give a roadmap at the beginning of trainings when I do them, and I'm afraid today is going to be more of a zigzag. I don't know that there's, it's going to be, those old country roads when you go for a drive in the afternoon. It's going to be a zigzag through definitions. I want to take us back to the basics a little bit to talk about way things have been written and put in the law. It's funny, sometimes we'll have conversations around here in the office talking about a specific issue, and somebody will just say, well, what's the law say? And it's like, well, let's get back to the actual text in the right to know law versus trying to interpret it from cases and from even final determinations. Briefly touch on aggregate data and aggregated data and why that is important. Different kinds of storage, and does it matter how you store? We've looked at the different kinds already, but does it matter how you store your information? What are the courts and the right to know law leading into the next topic? Well, not really topic, but area that we're going to discuss. How does the right to know law and case law handle storage and retrieval of information? So going way back, this is basic as you can get really for all intents and purposes of the right to know law. It all comes down to requesters are seeking records. And what is a record? And the definition is it's information. And that's the one thing you can take from this is remember it's information. And I'm not going to get into the legal definition of whether or not it's created, received, or trained pursuant to government business. And we're not going to discuss that. Our focus today is on its information that is stored or maintained electronically in a data processed or image processed document. And if that's not full of, and that's probably not even super technical jargon, but it's got a lot of technicalities in there and can get you lost and turned upside down pretty quickly. But basically, it's information that's electronically stored. I'm going to narrow it down to and pound this home today. It's information, and it's being stored and it's being maintained electronically. So getting into aggregated data, why is the term aggregated data important? It's because that, generally speaking, aggregated data is public information. Now, there's going to be exceptions to that general rule, but like if it's and those section numbers there, B1, B2, 3, 4, 5, that they're very commonsensical sections that would allow for an agency to withhold aggregated data. So national security, state security, security of a person or individual, if it's going to cause harm, and if it's going to release personal information and medical information primarily there. So, you're not going to release data in those situations and information in those situations anyway. But generally speaking, aggregated data is public information, and that's why that term is important. Now, the definition of aggregated data, because the right to know law actually goes through and defines it. And it's a tabulation of data which relate to broad classes, groups, or categories so that it's not possible to distinguish the properties of individuals within those classes, groups, or categories. And if you're like me, your first response is kind of, you lost me at tabulation. So working through this definition, what is Data. Data is, again, facts and statistics collected together. So you're gathering a whole bunch of information on maybe specific people, like we saw with the Department of Health. There was records kept on who tested positive for COVID, and a number of those types of records were kept. Again, information. The aggregate data part is the total number. So you got all these numbers. So there's 15 people from this county that tested positive. The aggregated data would be the addition of all those people that tested positive together. That's a very simplistic definition, I know, but that kind of puts it in its most simplest terms. You would not be able to get the individual information of those people, definitely not get their names and the home addresses and information like that, but even any information that would even slightly hint that you could identify them would be off limits. But the aggregate total of 15 people testing positive in Dauphin County would be considered aggregate data and available. And as I go forward, like I said, I'm going to use that term information, data, record. Those are all going to be used interchangeably, even though there may be the ability for a person with technical experience to differentiate between them in a definition, and probably in some of the final determinations, it may, depending on whether it's fact specific, be interchangeably and deciphered too, and brought out as individual words and terms that might need to be defined. So the question comes down is the agency collects the data, and as they store it, does it matter really how the agency goes about saving the information or storing the information? And there's retention laws, and I'm sure that Commonwealth agency has policies with respect to how data should be saved and information should be saved. But for purposes of the right to know law, there's no definite requirement on how you should or should not maintain your records. Although the court has come down and said in the Laguerre case, you do have to organize them. You don't have to organize, but you're going to be on the hook to have them organized in a way that allows you to respond to right to know requests. So in the Laguerre case, someone filed a right to know request for a bunch of determination letters. So it's a specific type of letter. And the files were, the termination letter would be in each separate file. There wasn't like one big bundled file of the determination letters. And the argument from the agency was, well, we don't think we have to go pull those out of each individual file. That would be, creating a new, I'm not sure if they are going to be creating a new record, but it would be compiling in a way we don't organize it. And the court said, no, the requester doesn't bear the burden of you not organizing your files in a way that makes it easy for you to go get a record that a requester has sought. So the fact that the DEP doesn't catalog them or organize them a certain way should not be held against the requester. And it doesn't make a request overly broad if it's difficult for you to track that information down. It's going to require a lot of work, a lot of records. It doesn't matter. You're on the hook. Go get those. So when you think this through, one of the things I advise agencies on is really stop and think about what your retention policy says, and don't get into the habit of just saving information and never monitoring what you saved and what you've kept. I kind of compare it in my personal life to when I go on vacation, or even just a day-to-day life when you're using a camera, or even worse, your phone, and you're taking all kinds of pictures. And instead of going back through and looking at the pictures and the 20 pictures you took, picking out the 2 you're going to keep, you just keep taking more and more pictures. And then when the video card fills up, you go buy another one. Or if you're on your phone, your cloud storage fills up. You just decide, well, I'll take, the $1 a month to get a little more data storage. And you reach a point where you want to put together a presentation or something, and now you have millions of pictures to go through, instead of if you'd monitored and edited them like you should have. Same can go for government records. With these drives nowadays, you can literally store in a office drawer probably what is it equivalent to warehouses full of paper copies from a decade or even 20, 30 years ago. You figure warehouses full of documents now in a file cabinet. if you're maintaining those records and a right to know request comes in, you're responsible as an agency to track down responsive records. I understand, and you know the first thought's going to be it has to be a specific enough request, and that is true. But as we look at the Laguerre case, and the Laguerre case is a good case to go back and reread, you can see that it's still your responsibility as an agency to go get those responsive records. And as you heard from my earlier point, you can see this is a 2012 case, so we're already looking at this one being 10 years old. So again, you do have some dated case law that you're going to see as we work through these, and dated in the concept of technology and the advancement of technology, not necessarily in the legal realm. So common questions to ask as you work through these, and here's my part where I'm saying the subject matter today is going to create more questions. Is, you know, first off, is the agency and is the info in your database or in your whatever software you may use, or you know, the cloud, whatever it is you use to store your information, is the information that's being requested in there? And we already talked about it. It doesn't matter how difficult. It doesn't matter how difficult it is to extract. If you have the information stored in there, does the agency have to organize it in a certain way? And we'll get into that in a little bit later. But you know, what is the format? Format produces even some of its own questions, which we'll talk about as well. What does it mean to compile, extract, export, organize information? What does it mean to create a new record? What information is available to the employees? There's some case law on that we're going to talk about. Is the info available in a way the agency usually conducts business? Is that what available means? Is that it's in the usual way? Is the info, and I got a redundant one there, is the info available to employees? But in looking at these questions, generally speaking, the courts have stayed and the Office of Open Records as well, has stayed very general in addressing these terms and in addressing these concepts and in addressing this subject matter. And the onslaught of cases caused really by COVID and the data storage is going to lead the Office of Open Records and eventually the courts to get more specific in dealing with these issues. And as time goes on and as technology develops, we're coming up with different ways to store data. It's going to involve different legal questions, different legal issues. It's going to require us to discuss these on some intricate, detailed levels that are going to, I think, be probably difficult to navigate. What complicates it further is these are case-by-case determinations. Now, this quote from a Commonwealth Court case was relating to electronic redaction, but the same principle applies to trying to figure out what information can be extracted, what information needs to be pulled out of a database, whether or not an agency doing certain things to the data involves creating a new record or compiling it in a different way or organizing it in a different way. And it is a fact-sensitive balancing test, really, in each case, and it's going to be determinative, and it's going to be determined based upon facts that are presented. And that's why it's so important that both agency and requester explain the capabilities of the database. Requester can do it from the standpoint of what they understand it to be and explain the terms, and the requester can make sure that they do a search that is as detailed as it can be to direct the agency where to find the records. One of the big issues we've seen is the difference between creation of a record and the extraction of information from, for example, a database. There is a difference between the two. And Section 705 of the Right to Know law says an agency shall not be required to create a record which does not currently exist. So we plug in our magic little word of information and says an agency should not be required to create information which does not currently exist. or compile, maintain, format, or organize a record in a manner which the agency does not currently compile, maintain, format, or organize the information. So this early on was, especially in the database realm, agencies were arguing that if I have to pull out and extract data from a database and put it into, say, Excel, that I've created a new record. And that came up before the Office of Open Records into the Commonwealth Court, and the decision was drawing information from a database does not constitute creating a record. So I'm going to click back here, when we stop and think about, okay, so pulling it out does not mean it's the creation of a record. So if I'm pulling it out, at what point am I now that it's pulled out and put in Excel, at what point am I as an agency required to do additional things to it that goes beyond what I have a responsibility to do in the aspect of compile, maintain, format, or organize? An agency can be required to draw information from a database. Can an agency be required to put it in alphabetical order? It's an interesting question. In short, to the extent requested information exists in the database, it's got to be provided. To hold otherwise would encourage an agency to avoid disclosing the public record. So an agency can't use the database as a means or an opportunity to put information in there and just it's never becomes available to the requesters. And that's why I would, here is a caution to agencies, if you're looking at software or looking at a new storage database to store your information in, it might be a good idea to make sure that anything you can pull out of that database could potentially be provided. It would be at least in a format, electronic format, that would be readable or usable by a requester. I know there are certain, and we'll get to this in a minute, but there are certain databases and software setups where the transactional databases, where it goes into the database, it's not really saved anywhere, but it is made available on a website. That's a different scenario than just putting it in a database and trying to get the information out and not be able to get the requester. We had a situation where, and I don't know that it ever came to an appeal, but somebody had called in and asked, they're trying to get information from a database from an agency, and the agency could give the information, but it was basically a bunch of gobbledygook without the software. And you'd have to have the software to use and look at and read the information. And I know there's probably, I'm getting into intricacies beyond my skill level, but I think you have to be very cautious in that situation. There may be certain types of information in areas that it requires you to have that software, but I think you got to be careful as an agency getting that software or that type of database and not being able to provide public access potentially if it's needed. Now, and this is coming straight from the law, it must be simply provided to requesters in the same format that it would be available to agency personnel. And so, and these are very general terms. And again, these are the very general terms that are out there with respect to court cases. And you look at format, and even the definition, or not even definition, but the concept of format, you have electronic versus paper. That's a format. You have a .doc document, which would be a Word document, versus a .pdf. So the Adobe. So that's a format. You have even the way it's ordered, chronological, alphabetical. That same format, to put it in alphabetical order, is available to agency personnel. Chronological, alphabetical, even the way margins or columns are arranged could be looked at as format. Now, I know you're going way down a road there that I think you reach a point where it becomes unreasonable to work through some of these things with respect to where we've been on these issues, but I'm just kind of trying to use this as a way to highlight the level of detail that you can go down to look at what format is. And then available to agency personnel. does that mean in the regular course of business? Does that just mean it's out there? I can go get it at any time? Does it mean, that I can go to my IT people and they can work their magic that they always seem to do and obtain it for me? Again, these are questions that are going to have to be addressed in a fact-specific situation, and it's really going to depend. And like I said earlier, I'm just highlighting them, bringing them to your attention, and having you make note that these are issues that we're going to be addressing as they come in and become available to the Office of Open Records, with hopefully eventually the courts weighing in and giving us more guidance than 2012 cases or 2013 cases, and give a little more updated and detailed review. It's also worth pointing out that the Commonwealth Court that made these decisions is totally different in makeup now than it was then. I mean, there's a lot of new judges that are now sitting on the Commonwealth Court. Here's the transactional one that I was referring to. Recent case that we had for a list of, I believe it was elevator inspections or elevator licenses, but in any event, what was requested is not as important as the fact that it's a transactional database designed to protect the integrity of the data, and in those situations, they allow it to be easily retrieved. They also posted stuff on the website. A lot of times these databases will link to websites. In those situations, if you're an agency and have a database set up like that with the information available on the website, you can point the requester to the website to get that information. Now, I will say that in pointing them to that website to get the information, you need to be clear that all the information that they're requesting is available there. We see cases come up from time to time where agencies will point them to the website, and only some of what has been requested is available on the website. The rest is still within the database and is not made publicly available instantly in the transfer from the database to the website. And in those situations, again, to emphasize under Laguerre, you're going to be responsible to provide access to responsive records. Now, just as a caveat and just as a note, I do realize that you may need to make them available because even though they're subject to the right to know law, obviously exemptions may apply that you would want to bring up. Exemptions may apply that will completely exempt that information, and that's another issue that would be discussed, and we're not really going to get into any of those discussions today. We're just focusing on actually getting to the data. So tips to agencies that in thinking this through. Understand what is being requested. And I know this gets into the issue of specificity, which has become more and more an issue at the Office of Open Records. And I think it is in large part due to the huge spike we've had in appeals. Like last year was a record number of appeals. This year, we again are on pace. I know it's still early in the year, but we were on pace for another record year. And we have a lot of people who are curious now about what government is doing, especially in the school district realm, elections, Department of Health, a lot of requests to those agencies driving that. And with that has come some first-time users. So the tendency can be sometimes to ask overbroad requests. So to the agencies, work with the requesters that come to you with a request that you think they may know what you may think you know what they're asking, but you're not quite sure. So reach out. A big one here: know what, how, where information is stored. And like I talked earlier about different people having different expertise, different knowledge levels. Work with them to properly look for the information that's been requested in your database. Make sure you have a knowledgeable person looking, which ties into knowing your information retrieval tools and capabilities. It might be able to surpass what you think. I've had a number of conversations with people, and I'm jumping down on my list to the different types of searches that are available. And there is a tendency to run very simplistic searches. So a right to know request is filed for any records, related to a certain topic, and people will give keywords to try to help. And we discourage against the use of keywords because sometimes they muddy the water. We'll see that when I talk about requesters. But you get those keywords, and instead of putting searches together that might find records or might limit it so that you can narrow it, they're entered just automatically using the word or. So it's like, I'm going to type in the word mask. Now I'm going to type in the word mandate. Oh, wow. It came back with, 50,000 hits. This is not a specific request. Where if you put mask mandate together as one word in quotation marks, you might bring back only 20,000. And now you combine mask mandate with email from Joe Smith as your search terms. Oh, now I've gone from 25,000 to 100. And that one of the basic searches in databases and searches in general is the Boolean search. And I joke around as I was talking to people today. I said, hey, it sounds like a Star Trek episode. And somebody said, oh, it sounds like a soup cube. So no, it's a type of search that is very basic, and was explained to me as somebody saying even the most basic databases typically have this type of search. And it's one of the things as an office we're going to be looking into, clarifying with agencies how they are searching for these records. What type of search terms or search mechanisms are they using? And in the same respect, I think requesters can be a lot more specific in what type of search terms and how they want those search terms used to be used to help find the records for a request. The intent is to find responsive records and not to make the request appear to be insufficiently specific. And that's where I mentioned bringing back those 50,000. Sometimes your requests, we've all seen them. I want all emails sent from and to the Office of Open Records in 2019. Well, obviously that's way too broad, and we've all seen those, and that's not gonna fly. But there are a lot of times we will see appeals come in where the agencies probably have a better inkling of what's being requested than they are letting on. And those are the situations where you really need to pay attention to the search terms and how you can use your tools in your database and in your storage software to better find records. I think of it with respect to tools. You walk into we get a right to know request. You walk into the warehouse and you look around, there's no boxes on the floor, and you say, oh, there's no records. You get a chair up and you can step up and look on top of a shelf, and you're like, well, still no records. But you get the ladder and you get to the top shelf and you go, here they are. Know your tools, know how to be able to find things and confirm that when you get to the top of the ladder and you look all the way down, oh, there's definitely no records. I've looked everywhere, versus just stepping up on the chair and not really completing a search that's complete and thorough. So I guess even to draw into legal terms, there is a difference between potentially conducting a good faith search and a thorough search, because if you're conducting a good faith search is going to involve, I think people really legitimately go and think they're doing a really good search, but they may not be using all the tools that are available in the database. I think that's what I'm trying to get across. I'm going to try to stay away from wandering into the difference between good faith search and a thorough search, and maybe we'll address that issue in a future FD, which is a final determination. Like I said earlier, share capabilities with the requester where appropriate. That can help improve requests. Train staff within the agency on what's available. I've seen some agencies, and I think it's advisable, handing off these searches to their IT. I also realize that it's a much different world in local agencies sometimes than it is Commonwealth agencies. Commonwealth agencies sometimes, many times, have the advantage of being able to go to a central location and give it to a centralized IT person that can track down any number of records for them. The same is not always true for local agencies. They might not have that advantage. They may have a very limited IT budget, and working with those people can help. If you work for one of those type of agencies, one of the things I can recommend maybe is like a quick YouTube course on how a certain database works. That's been beneficial, I've heard, to different people. So educate yourself or train your staff so that you can be able to be responsive to these right-to-know requests that come in. Tips to requesters. Like I said, know the storage and retrieval tools and capabilities just like the agency does. And I know a lot of times I say that, and then you turn around and say, well, how am I supposed to know them? And, it might help sometimes just to ask. I know that at times relationships between agencies and requesters can be strained and can even be volatile depending on the issues at hand. But it's worthwhile to work together through these and to be, we said this yesterday, to work together in a common sense manner and showing common courtesy and try to get to the bottom of what records you want and what records and information the agency is able to give you. And then if you can't agree on what you think should be available or what is available or what is public, that's what the Office of Open Records is for, and you can appeal to us. Both knowing that when you come before us, being specific and clear on what those capabilities are is very helpful to the appeals officer. So with respect to being specific and clear, we talked about that. Use of keywords is discouraged. Many times people and requesters intend that to be a guide and help to the agency, and I think many times it muddies the waters. If you're going to use the keywords or suggested searches, I think it helps to explain what you intend and provide a lot more detail. Otherwise, a lot of times it's used to broaden, I shouldn't say it's used to broaden the search. I think it just, by nature of the way things are phrased, it will broaden the search beyond your intent and bring back many more documents than you intend to see. I already discussed number 3 about if you give search terms or keywords, explain how they should be used. Should the terms and words be used as a group or individually? You can use, reference that Boolean search. That might help a lot to help an agency, and maybe go read on what a Boolean search is and maybe propose a Boolean search as part of your request. We haven't seen that too much. It seems like it would be helpful, but it's something to maybe work through this new area that we're seeing more and more interest and more cases come from. And give necessary context to the request. Sometimes requesters will just file things with the agency expecting them to know what they're talking about. They may have called and talked with someone. That's not necessarily going to be the case, especially when you're dealing with larger agencies. Try to give some type of guidance there to be able to work through that request for the agency. So I had one last thing I wanted to go over, and that is a court decision, and it kind of relates back to the Gingrich case, which was another case, this one from 2011. It's unreported, so not only is it dated, it's unreported. But again, it emphasized this was a request for a large amount of data related to the deer harvesting and deer totals that were in a specific area. Let me see here. It was one of the counties. It's irrelevant to it. I'm waxing and being more attorney-ish and trying to narrow down the facts of the case. But what the court noted was the same thing that we've noticed. To the extent that the data exists in some format, the agency is obligated to provide it. And you're going to need to disclose the responsive data in any format in which the information exists. And again, like I said, early on, the definition of format was electronic versus paper. That was basically when we at the Office of Open Records, that was the initial thing we looked at. It got a little more beyond that when we started to look at whether or not Word documents, .doc, .pdf, whether it had to be produced in PDF. And this has gone back and forth a couple times. I know with different issues that have come up before us. Again, it's fact specific, but I think at this point, either one would be available to the requester. And then the question becomes, formatting, how much farther beyond that does the definition of format extend? And those are some of the issues that we're going to be looking at in much more detail than has been looked at in the past. And like I said, that's part of today's intent, is to let parties on both sides of this issue, requester and agency, know that there's going to be more expected, I guess, from both parties to explain to us what's going on with the searches, because we're put in a position of handling a high volume of not just cases, but complex cases. And we really need the parties to step up and explain to us in a little more detail what exactly is going on in any given appeal with respect to your database at your agency, or as a requester, what exactly you intend with your request and what you're trying to get to. So I think, I mentioned it yesterday in one of the webinars we did with respect to specificity. A burden's not on the requester. However, it's a good thing for the requester to explain why they feel their request is specific. It's a good thing for the requester to explain why they gave the search terms that they gave. And on the flip side, it's going to be very important for the agency to explain why they're denying access based upon their capabilities and tools within their database or software that they're storing their software. So that is the extent of my presentation for today. I am opening up to questions. If you have any, feel free to type them in the chat. I will be unable to answer specific questions because we may be handling the issues that you might have in a specific situation in an appeal or coming in an appeal soon. I can just generally discuss it. I'll give a couple minutes here, well, not a couple minutes, but a few seconds here for people to type in any questions they have, and then we can sign off. And those of you that are missing your college basketball game can sign back in and watch your college basketball games. All right, so either everybody's asleep or there's no questions. So I hope you all have a great weekend. It has been a good sunshine week. We've been able to cover a lot of different issues. And as we go forward, I guess the only thing I can emphasize and say again is let's really work on, there's a question in at the last seconds. How have agencies provided information from a database? I think there's any number of ways that they've done that. I think, if I'm not mistaken, the most common I think I've seen is exporting it into Excel. I'm not sure the detail level of what you're looking for as far as how they've provided it. I know some have provided printouts. I think it really depends. You've taken one step away from the technological advances of it, and I don't know specific answers on that. I don't know if there's other ways from Excel that they've done that, because typically they will argue before us whether the information has been provided or not. If there's any appeals officer on there, feel free to, I think we have a couple appeals officers listening. If you know of another situation where they have provided in a different format, because a lot of times we'll get the appeal, it'll come in and we will be deciding whether or not access will be granted. I don't know that we necessarily know how it was provided and in what format it was provided. Sometimes that comes up and sometimes we'll know it was Excel. I don't know if there are other database softwares like Excel where you're allowed to export it. I just know that sometimes it's in Excel. So I could have a better answer for you, but of it. Does that help in some respect, Jessica, or do you need some more detail? And again, if there's any questions you have that you didn't feel like typing in, or you don't know what a case or final determination may have, or you're not sure how it may have applied to your situation, or if there could be additional info related to that case, feel free to reach out to me, give me a call or shoot me an email, and we can work on getting you at least some final determinations or case law that will help you try to reach your own conclusion in these matters. All right, so if there's no more questions, thank you all. Have a great weekend. As I was saying before I answered Jessica's question, really, I really emphasize to people that work hard on being and using common sense and common courtesy. It's like just this last week, we've had so many situations where the volatility of these situations continues to go up. So I just encourage everybody to be nice and be courteous and work through things together, and we can then handle your appeals as they come to us. So everybody have a great weekend. I didn't get a chance to look at the weather, but hopefully it's a beautiful weekend and we can get into spring here and enjoy some warm weather. Thank you all, and we'll see you hopefully not too often, but on your appeals when you come before us. Thanks again. Bye-bye.